All right, so this is chapter 3, and we'll be talking about trademarks. So in chapter 2, we discussed copyright, and now we go through trademarks. Chapter 4, we'll look at patents. So the agenda for this chapter is we'll first of all understand and define what a trademark is, and look at the act, the law that substantiates the definitions and other issues. And then we'll also understand the scope of trademark protection. So by learning what it is, we'll also understand how we can protect trademark. And then we'll look at the requirement, how we can register a trademark, and how we can publish, how do we inform, how we can inform the public our trademark is registered. And then we'll also explain the issues of likelihood of confusion. So whenever one trademark owner believes the other trademark may confuse their clients or their potential clients, they have courts will apply the likelihood of confusion test to understand whether a second trademark or name or use is being infringed. And we'll end this chapter by looking at cybersquatting, which is an offense through the internet, and also looking at some international treaties and conventions for trademarks. So let's start by explaining what a trademark is and what is the law applicable to trademarks in the US. So a trademark will be any word, any name or symbol or device or any combination of those that will be used to identify goods, services, or even companies. So what just comes to my mind now is the golden arches from McDonald's, or Coke, or Starbucks, or Tim Hortons, or BCAT, even Pearson here. Pearson is a registered trademark. So those are names or symbols or logos that will identify, that will help consumers to identify who the manufacturer is, what company the product or service comes from. So this is what a trademark is. And the act or the law that is related to trademarks in the US is the Trademark Act, which has a specific name as Lanham Act, but most regularly it will be referred as the Trademark Act. So it is there where we find this definition, what a trademark is, and based on its definition, we know how we can protect it. So I said there's trademarks for goods, for products, also for services. So if you provide a service, you can also have a trademark, and for companies. I'm not saying they are separate, but we have to look into what they are mostly protecting. So when we think about BCIT as a trademark, it is mostly protecting the company or the institution. It's an educational institution. So no other educational institutions will be able to have BCIT as a name, as a logo. because it is protected. Okay. Whereas, let's say Apple. Apple could be both for services because they have streaming services, iTunes, for example, but they also have a lot of products. So the Apple logo or name as a trademark is protecting both a product and a service and a company as well. Okay, so we this is important to be clear to you. So how trademarks protect businesses' products? Well, here are some examples of trademarks, and I've given you others as well. So BCAT, Netflix, you've got mail. This is a logo, which is a sentence, but this is a trademark that is owned by American Online. So the idea is that by looking at this trademarks, consumers know where either the product or services come from. Okay, so that's the idea. If you are, let's say, I don't like Starbucks coffee, I just like Tim Hortons, and you are approaching me with 2 cups of coffee, one is yours, the other you would give it to me, and I see those two are from Starbucks. I already know I don't like that. I know where they come from, where the coffee comes from, so I don't like them. And this is just an example because I like Starbucks a lot. And so also, let's say I'm teaching in the classroom, we need to use laptop computers, and there's a specific software, but this software, let's say, does not run on Macs. So I can see from the students' laptop computers who has a Mac, who does not have a Mac, and if we'll have a problem or not. So again, keep this idea that trademark is mainly focused on clients, on consumers, so that they do not confuse where the product or service comes from. Okay, so that's the idea of trademark. I want my clients to be sure they are buying my product, my original product, my only product, or my service, or either products or services coming from my company. So I'm going to use trademark for this. Okay. If a term is generic, and this may be a bit logical, but sometimes it's not so straightforward. So companies will need to go to court. But if the term is too generic, this cannot be registered as a trademark. You can still use it, but you don't have protection in terms of preventing others from using this generic term because it's generic. It cannot be registered. So, like hotels.com, they try to have this registered as a trademark, but the USPTO, the US Patent and Trademark Office, said no, this is too generic, and the company went to court to try to reverse this decision from the USPTO, and they were not successful. So the courts confirmed that hotels.com could not be registered as a trademark or could not receive trademark protection because it is generic. It is too generic. Okay. This, by the way, we are here. This is live, so let me correct this here. All right. So, how long is trademark protection? It is 10 years in most countries, not all. By the way, in Canada, it used to be 15 years, but last year there was a change in the Trademark Act here in Canada, so now it is 10 years as well. However, the good thing here is that you can renew this registration indefinitely. So remember we discussed copyright, and copyright is valid the life of the author plus 70 years or 95 years. So there were a specific time length for copyright. And then once that time passed by, the copyrighted material would be in public domain. So no protection anymore. Here for trademark, it is different. Once you register your trademark, it is going to be protected for 10 years. But as long as you renew just before it expires, the 10-year period, you have another 10-year time protection. And you can be renewing it indefinitely. Okay? And the question would be, so if I have trademark protection in the US, do I automatically have trademark protection in Canada? No. The answer is no. Why? Remember I told you in copyright, or when we briefly discussed about intellectual property as a whole, IP, and each type of IP, so trademark is one of the type of IP, they are national in scope. The laws are applicable only within the boundaries of that country. So if you want to have trademark protection in other countries, you have to apply, you have to register in those other countries. And in those other countries, most likely it will be renewed, possible to renew indefinitely after either 10, 15 years, so depending on that country's specific length of protection. But you have to renew in each and every country. Okay? There's one main substantive or one main order requirement for such renew to be valid. You need to be using the trademark in commerce. So you cannot have abandoned. So let's say you started your business, you register your trademark, you are going well, 10 years now, so you renew your trademark. But let's say 5 years after you renewed, you decided to go out of business. You're not in business anymore for whatever reasons. So you cannot renew it again after 10 years. Why? Because you are not using it in commerce anymore. You decided to shut down your business. So the main requirement is that you are using the trademark, you are actively using your trademark, your registered trademark in commerce, so that you can renew every 10 years. Okay, so that is important also to keep in mind. And one other thing that is important here, we're talking about registered trademark. So we'll discuss how to register them. But a trademark itself is not only a trademark after it is registered. Let's say you have or someone has a company and a name and a logo, a trademark, to say so, that is famous. Could be famous locally, just in the neighborhood, or even in the city, or in the province, or in the country. Well, but it's famous at some extent. So it means, and it is actively used in business. So it means this business owner has a trademark. The fact that the owner of the business has not registered the trademark means that this trademark owner cannot rely on the law, on the Trademark Act, on the Lanham Act, for remedies in case of infringements, in case of illegalities. But it doesn't mean that business owner does not own the trademark. Yes, they own the trademark. Okay, it is highly recommended to register a trademark, but keep in mind that having a trademark is not necessarily related to registering it. Again, very important to register, highly advisable and recommended to register, but it is not the registration that causes you to have a trademark. What causes you to have a trademark is that you have a name that is not confusing with other names or logos or sentences, but you are using it in commerce and you are using it in a way that helps your consumers, your clients to identify either your goods or services with it. Okay, so that's very important to know. But I told you, registration is highly recommended, highly advisable, because you have not only do you have an official record, but you can also use the Trademark Act remedies in case you face infringement. So you can only sue another person or business for trademark infringement if you have a registered trademark. Okay, and how do you register? Well, nowadays registration is highly or mostly made online. You can also do it in paper, but very few applications are made in paper. Mostly are online, and they are made through the USPTO, so the United States Patent and Trademark Office. This electronic application is called, the system is called TIS, which is the Trademark Electronic Application System, and you can do it yourself. You don't need to hire a trademark agent or an attorney. No, you can do it yourself. Yes, you need to read about the rules, you need to understand a little bit the system, but as long as you have a unique trademark, you have a logo or a name, and it is not confusing with others, you can do it yourself and you will not need to hire anyone to do this. Okay. By the way, I was checking. The USPTO has a channel at YouTube, and they have a lot of step-by-step videos or general principles and concepts explanation. So if you want to go further and deeper into registering a trademark, understanding how important it is to have it registered, I would recommend you to check on their YouTube channel or the US PTO website as well. One other important thing here is that so you try to register, you make your application for trademark registration, and let's say the examiner refuses it because it is allegedly confusing with others, or it is too generic, or any other grounds to refuse. So you can appeal within the USPTO. So your appeal will be heard by the Trial and Appeal Board. And if you still lose it, if they still decide that your trademark cannot be registered, then you can go to courts. So you would bring your case to courts, similarly to what hotels.com did, even though they also lost in court. But that's how you're gonna dispute the USPTO decisions. So in terms of marking, when you have a registered trademark, so after the registration is granted, after the registration is confirmed, so what happens? Well, to inform the public that your trademark is registered, you will use either the R under the circle symbol, or you can have the statement registered, USPTO, or register US Patent and Trademark Office. So any of those three, so this symbol here, just beside the trademark, or any of those two statements can be used for registered trademarks. So let me just come back here and this slide. So you can see here Netflix is not using anything, but BCAT is using the trademark symbol, not the registered one, but they are using TM. So I'll tell you that by using this TM, they are actually saying that the trademark is not registered. So if you have not registered with the USPTO, you cannot use any of those three. All you can use is TM for a trademark for a good when it is product trademark, or SM for a service mark. Okay, so what I'm saying here is that BCAT, by using the TM, it's either a mistake. They should have been using the R symbol if it is registered, or if it is not registered, this is correct. So it's trademark. I would guess it is registered, and this was a mistake from someone creating this. But anyways, by the way, let me check this. It's important for us to know, so I'll just go check this. All right, so checking online here, see the word BCAT was advertised but not registered yet. So one of the steps while registering a trademark here in Canada, it is to advertise so that others can oppose to that registration. Others can come to the trademark office here in Canada and say, hey, I just learned that BCAT is trying to register their word, and it is confusing with mine, and mine I had acquired long time ago, etc. So the advertisement step is an important one. And if everything goes fine after advertisement, so no oppositions, no issues, then it may be registered. So the word is not registered yet, but we can see that, oh, there's the word here. This one should be another one. So let's come here. The word here is registered. The design only advertised, but here the square design is registered. So again, I would say, let's come back here to the slides. Again, I would say the TM here is a mistake. It should be the R, the registered symbol, as we saw here. Okay, they should be using the here the R symbol, because it is a registered trademark already. Okay, in any event, if you want to know if the logo you're thinking about, the name or symbol you are thinking about, is already registered by someone or not, you can go to the trademark office in Canada or to the USPTO in the US and search, make a search on that name, so that you avoid trying to register and then being opposed by a company that already owns that trademark. So in case you have a registered trademark and someone else is using your trademark, it's very common in the fashion industry. There's a lot of fake Gucci, Louis Vuitton products, Nike. So in the fashion industry, there's a lot of fake goods. And how is this dealt with by the Trademark Act? Well, the thing is, you are suing, you are the owner of the trademark, so you have the burden of proof. So you have the burden of proving that those goods are either fake, or if they are not fake, but someone is using a trademark that is very similar to yours or is causing confusion to your clients, then you have the burden of proof um, on the likelihood of confusion test. Okay, and the factors that the court will take into consideration are how similar the marks are. Could be in terms of the name, the spelling, could be in terms of the logo, design. So anything that could cause the similarity thought in the consumers. Courts will also look at the intent of the alleged infringer. So the one that is using your trade, using your illegally using, that's what I mean. So the one that is allegedly illegally using a trademark that is similar to yours, what are their intent? Do they actually intend to get your clients, your consumers? So are you in the same business industry? Are you in the same field? So the closer the field is, the more the intention of the infringer or alleged infringer, um, the more there will be intention for that infringer because they actually want to steal to get your clients. Okay, but if you are in different industries, even though you may be using a similar name or logo, very different industry. One is in the industry of coffee only, the other is in the industry of um, let's say English lessons. So those are, one is service, the other is product. Also, food industry, food and drinks industry. The other is education. So those would be different. An alleged infringer of English classes would not be intending to steal clients from a coffee shop, for example. Okay, and then evidence of actual confusion. So this is how do trademark owners usually prove this? They usually have consumer surveys. So they go out and try to survey people and say, hey, do you think those trademarks are confusing? And if you say yes, how, why? So they usually bring those surveys of consumers, of customers to court. And then similarity of products and the manner of marketing, again, related to the intent here, degree of care that purchasers would need to exercise. Again, if you're in the same field, the degree of care would be higher. Okay, if you're in different fields, there's no care. Well, I can be acquiring a product or service with the same name, but we are in different industries. Not much of an issue if you are in different industries. And the last factor would be the strength or weakness of the marks. So how famous they are, how already inserted into business, into the mind of consumers they are. This would also be taken into consideration. Okay, again, the burden of proof is on the one suing, the one is on the plaintiff, is on whoever is suing the other for an alleged trademark infringement. um, this is, I just discussed, the burden of proof and also the survey of customers as an evidence. So in terms of the ACPA, the Anti-Cybersquatting Consumer Protection Act of 1999. So what is, first of all, what is cybersquatting? Cybersquatting is when someone registers a domain name with the intent to sell it to the trademark owner. So let's go back to the 90s, late 80s, when internet started. Some people were smart enough to register famous logos, names as web domain in their own countries with the only intention to sell to the trademark owner. So I would register bmw.com.br in my country, in Brazil, for example. And when BMW wants to come to Brazil, I would sell this domain to them. So the fact that I did not have any business related to cars, the fact that BMW is worldwide famous. There's bad faith in my side. It is presumed to be bad faith on my side because my own intention was to sell to BMW. This is what cybersquatting means. Okay, so this ACPA, this Consumer Protection Act, the Anti-Cybersquatting Act, authorizes the trademark owner to get a court order transferring the ownership of this domain name to themselves. So if they prove that the person registering that domain name was actually involved in a cyber squatting wrongdoing, they can get an order from the court. Okay, and it was not like this before the late 90s. So there were still a lot of people making a lot of money worldwide with cyber squatting. But then the US specifically came up with this ACPA, trying to um, reach such a prevention. And we also have the World Intellectual Property Organization, WIPO, and they have a domain name dispute resolution system in their mediation and arbitration tribunal. And a lot of countries, including Canada and the US, they have adopted um, those rules in order to allow trademark owners to seek for um, ownership of a domain name that was a victim of a cyber squatter. So it is called the Uniform Domain Name Dispute Resolution Policy, the UDRP. This one from the WIPO, the World Intellectual Property Organization, and several countries have adopted them. If a company wants to fight a domain name that is related to their trademark, even if their country does not have their own law, such as the US, the ACPA, but they are part of the World Intellectual Property Organization. So this trademark owner can make use of the UDRP, this Uniform Domain Name Dispute Resolution, to seek ownership of that domain name. Very, very interesting mechanism to fight cyber squatting. Moving on, so we have this dilution concept. So dilution of a trademark, or known as trademark dilution, which is when a trademark is so famous that people start referring to the product as the trademark. So an example would be Kleenex. So Kleenex, instead of saying, hey, can you buy tissue for me, or would you have any tissue for me? I just say, do you have Kleenex or Kleenex? Or can you buy Kleenex for me? So I'm referring to tissues. However, Kleenex became so famous that people do not refer to tissues anymore. And before this act in the US, so there was this case mostly versus the V-Secret Catalog Inc. And the Supreme Court of the US decided that the plaintiff, they would need to establish an actual dilution proof. So they would need to show in the real world uh, with surveys, with a lot of evidence that the actual dilution took place for their trademark. And then the Congress of the United States passed new law, which is this Trademark Dilution Revision Act, that changed this or reversed this case law from the US Supreme Court. So under the new act, now the plaintiff needs to only establish a likelihood of a dilution. So the burden here is not so high. The standard here is not as high as it was in the Mosley case. So establishing a likelihood of confusion um, is much easier uh, than establishing the actual dilution. Imagine proving actual dilution in a country, in a big country such as the US. You would need to survey the whole country. You would need to spend a lot of money. Okay, so now let's talk about the defenses to infringement of trademarks. So if you believe your trademark, your registered trademark, was infringed, and then you sue, the alleged infringer can rely on these defenses mainly. The first one is the First Amendment and parody. So based on our free speech right, we can make fun, we can use trademarks as parody, and we will not be infringing that trademark. So there are like websites. Well, I don't know if there are, but I've heard there may be websites such as, let's say, I hate Starbucks.com. Well, this is not infringing the Starbucks because I'm just using this website, for example. I would be using this website to complain about Starbucks, and as long as I do not lie or comments there are not false in content, they're just opinions, they would be based on the free speech right Americans have. So that is an example of the First Amendment and parody uh, defense. The other defense is related to latches, and latches is actually delay. Delay taking too much time to pursue your right. So you believe your trademark is being infringed, but you just take time. You just delay in suing the alleged infringer. So if you delay to pursue your right in a way that it causes prejudice, in a way that it causes negative effects to the alleged infringer, they can rely on those in these latches defense. Not always successful, but it can be used as a defense. The unclean hands defense is related to the fact that there were wrongful conduct on the plaintiff, on the trademark owner. And because they were involved in any wrongful conduct, let's say the trademark owner has acted with bad intention or bad intent, then the unclean hands defense could be used. But here this is also a defense that is not usually successful because the requirements here are quite tough to be met. So, but this defense exists, even though it is rarely successful. And the last one is when the alleged infringer claims that there was fraud in obtaining the trademark registration. So in other words, the alleged infringer is saying, hey, this trademark is only registered because there was fraud during the application. However, even if the alleged infringer establishes that there was fraud in obtaining the trademark registration, it could be the case that the owner of that registered trademark had been using the trademark for long ago before its registration. So remember I told you in the very beginning of this lecture, acquiring or having a trademark is not related to having it registered per se. Highly recommended to have it registered, highly advisable, but owning a trademark means you are using a name, a logo, a symbol in business, actively in business, and it has been identifying either your products, services, or company for a long time. So what I'm saying is I may still have rights in that trademark, even though when I registered it, when I had it registered, it was based on a fraudulent process. Okay, so yes, this defense is available and can be successful, but there's also this aspect of the trademark being owned by the owner some time ago or before the registration. So moving on, as the last part, we look at the international enforcement of trademarks. And here I want to highlight a convention, one protocol, and one treaty. So the Paris Convention, which has 177 countries as of now. The main concept or the underlying principle for the convention is that foreign nationals trying to register a trademark in any of these 177 countries need to be offered the same treatment as if they were citizens of that country. So in other words, foreigners and nationals, foreigners and citizens, they have to be treated equally in terms of trademark application. The Madrid Protocol, this is a very important and interesting one. By the way, Canada became part of the Madrid Protocol just last year. And the Madrid Protocol is a highly efficient way to register trademark in several countries. Why? Because with only one filling, so you file your trademark registration here in Canada because you are here in Canada, but you want protection in other countries as well. So you opt in for the Madrid Protocol, and based on your only one filling here in Canada, you are also filling for trademark application in all other countries that are part of the Madrid Protocol as you want. So it's a high cost effective, highly efficient way not only to register a trademark, but once it is registered, also to have it protected internationally. Again, it is not an international trademark you will have. It is just a way, a system that allows you to register your domestic trademark at the same time internationally in other countries. And the treaty is the Trademark Law Treaty that is present in 54 countries as of now. And the idea of the Trademark Law Treaty was to harmonize and unify the administrative requirements for trademark registration. So there are still countries that have a lot of administrative requirements for trademarks to be registered, and because the national law is only applied to that country. So the idea of the treaty is that countries that have signed that treaty, they have similar if not the same, administrative requirement for trademark registration. The idea here was to help to make the process smoother for trademark applicants. mainly when we are applying internationally, because I would be applying here in Canada before the Madrid Protocol, and I would want to apply in the US, in Mexico, in um, France, in Germany, and the requirements are different because of domestic and local legislation. So the idea of the treaty was to harmonize, to unify. So I know that countries that have adopted the trademark law treaty, they have very similar, if not the same, administrative requirements. So as a trademark owner, it saves money, it saves work, and so on. So that's what I wanted to share with you about trademarks. We went through the definition, the scope, how we acquire a trademark, and then the registration process, what a trademark is, and then how we mark a registered trademark with the R symbol or those two statements registered with the USPTO. And if a trademark is not registered, we can use the TM for a product trademark, or a company, or a service trademark. We would use the SM uh, service mark, but it is not registered. And we also discussed about domain names, mainly focusing on the cybersquatting wrongdoings that took place and still take place um, in some countries. And last but not least, we looked at the defenses for alleged infringement of trademarks and the international enforcement of trademarks. Thank you, and we'll see ourselves again, or we'll be discussing about IP again in Chapter 4 for patents. Thank you, bye.